All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning, everyone, in and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is case KSC BC 2020-04, the Specialist Prosecutor versus Pjetër, Shala.
Thank you, Madam Court Officer. Now I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Good morning, Your Honor. Appearing today for the prosecution, Specialist Deputy Prosecutor Mr. Whiting, Prosecutor Sean O'Dowd, Marlene Yaya Haag, Legal Officer, and Angel Langeberg, Case Manager. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense, please.
Good morning, Your Honor. I'm Mr. Jean-Louis Gillissen, and I appear before your court with Mr. Eddie Awini. Thank you very much.
Thank you very much, Mr. Gillissen. And for the record, I note that your client is appearing before the court via video conference. And for the record, I'm Nicolas Guillou, pretrial judge for this case. On 20th April, I scheduled the first status conference in this case. My goal today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss the status of the specialist prosecutor's investigations, the estimated amount of documentary and testimonial evidence the parties will bring to trial, issues related to the disclosure of supporting material to the indictment, additional material intended to use at trial, exculpatory evidence, and protected material. Then we will discuss the procedure for disclosure, the redaction regime to be adopted for the present proceedings, and finally, any other issues the parties may wish to raise. I thank the SPO and the defense for their written submissions, especially within this short time frame. And I will invite the parties to present their views in a concise fashion about each item listed on the agenda, which I will address individually. I remind the parties that should any submission require disclosure of confidential information, they should inform me so that we can go into private or closed session. Let me first move to the general questions. Before I give the floor to the parties, I wish to remind them of the general principles of disclosure in the legal framework of the specialist chambers. Disclosure is an inter partes process in electronic form, organized and facilitated through the registry's court management system. Disclosure shall be a priority for the prosecution at this stage, and the parties shall disclose evidence of true relevance to the case and not the greatest volume of evidence. In view of the publicity principle, evidence is registered as public unless there are reasons to classify otherwise. The disclosing party determines the appropriate level of classification of evidentiary items on a case-by-case basis. I would like to hear first from the prosecution on this topic, notably on the status of its investigations, the type of evidence it intends to use in the proceedings, and how many witnesses it intends to call at trial. Madam Prosecutor.
Thank you, Your Honor. As submitted in writing yesterday, we foresee very limited investigative steps which will be taking place during the pretrial proceedings. We do not foresee that such investigative steps will in any way delay the procedure. As to the second point, Your Honor asked, we will be presenting, we have already submitted 4 witnesses with the indictment supporting materials, and we are foreseeing to present about a maximum of 8 additional witnesses. This will be, this has been also submitted in writing yesterday. With regards to the third point Your Honor raised, we have submitted already a breakdown of what is contained in the supporting materials, and that is essentially covers mostly witness statements, a number of other documents, which include reports, orders, and other items. And we expect that the additional materials to be presented after the supporting materials have been disclosed will follow within those lines as well. Thank you, Your Honor.
Thank you, Madam Prosecutor. Now let me turn to the defense for their submissions on what the prosecution just presented and on the general questions point of the agenda of the status conference. We'll go in more detail later on each category of evidence and on the procedure, so just for the general questions here. Mr. Gillissen.
Thank you very much, Your Honor. Thank you for giving me the floor. With your permission, I would like to address a quick, very first point. I respectfully submit this is an important point because this is very special for us. We are a very brand new team of defense. And of course, as you know, I'm sure you're aware about the difficulties of this kind of situation. Mr. Awini and I, all cases ceasing, we take care to respond to the appointment of this first conference. But it's very difficult to deal with the mass of information we receive. And I can say just now, that's the very first point I would like to underline. We are not till now a fully operational defense team. I would like to underline it. Okay, thank you very much. So, with the very first point of the document we receive, the defense confirms its agreement and its stand to carry out investigations, but we are not now able to provide any information on the anticipated duration of its investigative activities. The defense is unable to indicate whether it will provide notice of an alibi or any other grounds of excluding criminal responsibility, but of course we will take contact with the court, with the SPO, to provide the information till we could have something. The defense confirmed its intention to apply a case-specific categorization in legal workflow for any disclosure to the prosecution, and accepts the proposed adoption of the case-specific subcategorization in legal workflow. We would like to propose some additional subcategories. One, criminal element, background, and on the third element, location, other. So the defense is willing to consider any proposed model consolidated disclosure chart. We receive some information about that. We are busy to discuss. We had a contact with the SPO about these possibilities to adopt something in an agreement, and we have the wish to inform you at the following statute conference. So, the big issue, in my opinion, is disclosure of material supporting the indictment, Rule 102. Because we received the proposal of the prosecutor, of course, but we request that the evidence supporting the indictment be disclosed as soon as possible, at least the very last, within 30 days of initial appearance of the accused. Till now, it was a unilateral procedure, and we understand it perfectly well, of course. But now we would like a total and clear contradictionary procedure. There is a number document of procedure. The feeling that we have that has been submitted to you, and we would like to obtain the filing and any transcript of hearing about the procedures in the past, to have a fully view on the procedure. We would like to obtain all documents, including the indictment, without any redaction, excepting, of course, the ones concerning the witness. But we have the opinion, and we submit respectfully, that the name of the victims, and particularly the one who is alleged to be a person who died, it's of course very important to know for Mr. Shala. That's why we would like, with the exception of the redaction concerning the witness, we would like to have an unconditional contradictory procedure about the past of this procedure. It means all the filings leading up to the arrest of Mr. Shala, and without any redaction, with the exception I told you just before. I think these documents are really the ones who are able to enable us to work effectively. That's the problem of the effectivity, of course. You know it perfectly well. So, with your permission, Mr. Awini will deal with a special point concerning the disclosure of Rule 102, 1B, material. I thank you, Your Honor.
Thank you, Mr. Gilson. We'll go into the details of each category one after the other, so I will give you the floor a little later, Mr. Ayuni. Mr. Gilson, I perfectly understand that the defense team is not fully operational. I mean, it's just been a couple of days, and I know I've been very fast scheduling the status conference, but let me just give the reasons. It's because we, and you, I think, want the SPO to disclose evidentiary material as soon as possible. And in order for the SPO to disclose the material, I have to issue a framework decision on disclosure. And for me to issue this framework decision on disclosure, I need your submissions, both from SPO and defense. And this is why I wanted to do it as early as possible, because this is a condition for you to get all the material as soon as possible. So, but I perfectly understand that, especially now, whether it's the composition of the defense team and your perspective on the case, investigations, it's absolutely understood that it's not possible for you to make any submissions on that. And to be fully honest, the burden at this stage is definitely more on the other side. It's definitely the SPO's duty to disclose all the evidence at this stage. That is the key point in this status conference. Let me now move to the different categories of evidentiary material, and we will start with the supporting material to the indictment, known as the Rule 102.1a material. I take note that yesterday, the SPO disclosed one batch of Rule 102.1a material to the defense, which includes non-witness related indictment supporting materials, as well as some statements obtained from the accused. The SPO anticipates being able to complete its disclosure by the end of the 30 days statutory timeframe. The defense requests that evidence supporting the indictment be disclosed as soon as possible and at the very latest within 30 days of the initial appearance of the accused. I invite the SPO to give any further submissions on the disclosure of the supporting material to the indictment and notably on the overall amount of evidentiary material, whether translations into Albanian of witness statements whom the SPO intend to call at trial have been finalized, and any other details the SPO wishes to provide. Madam Prosecutor, you have the floor.
Thank you, Your Honor. Yes, indeed, we intend to move the disclosure process forward as quickly as possible, and as Your Honor noted, we started our disclosure of Rule 102 1A materials yesterday. The items disclosed comprise a total of 22 items for 275 pages, 5 statements of the accused, and 17 other documents, meaning reports, political declarations, authorizations, and other orders. This is a part of the total amount of indictment supported materials that comprises 97 items for a total of 3,493 pages. The total number of the statements of the accused included in the indictment supporting material is 21 items. Each statement might be comprised of several items. That's why the number seems a little higher. Regarding the translation, Your Honor, the translation has been completed for some of the items. There's some translations that are still pending, and that will be, of course, done within the, we foresee that it will be completed within the statutory 30-day deadline. With regards to the witness-related materials, that disclosure will be done as soon as possible once protective measure motions have been addressed. So we foresee to also be ready to disclose very quickly, but that will have to wait until protective measures have been addressed. Thank you, Your Honor.
Thank you, Madam Prosecutor. Mr. Awini, on this supporting material to the indictment.
Thank you, Your Honor. Good morning to you, Your Honor, and to our learned colleagues, to everyone in the courtroom and around it. Just briefly, as Your Honor mentioned, we are here today to listen to what the SPO has to say about it. This is well noted and appreciated that he is willing and committed to disclose the most relevant documents as soon as possible, and if possible, well before the 30-day deadline. And we confirmed that we were in receipt of the first batch of 102 1A material. It was disclosed quite late in the evening. We didn't have a good chance or a fair chance to have a look at it, but I'm sure as we get more operational and more effective, as we are getting staffed, we will be able to deal with it, and that's the most important thing. Thank you, Your Honor.
Thank you, Mr. Awini. And I also add to what I mentioned to Mr. Gillissen before that you certainly remember my very long oral order on Monday with a lot of zeros. This also was a bit painful to hear for all of you, I'm sure, but this also was to be able to unclassify a certain number of documents so that you could have access to them as soon as possible. Let me now move to the second item on the agenda, which is the supporting material to the indictment, known as the Rule 102.1b material. I note that yesterday the SPO disclosed one batch of Rule 102.1b, excuse me, no, that is me messing up with the 1021A. I take note that the SPO expects to be ready to disclose further material under Rule 1021B by 30 July 2021, or in any case, no later than 30 days prior to the opening of the specialist prosecutor's case, subject only to protective measures being granted. The defense requests that such material be disclosed as soon as possible in both English and Albanian, and it submits that disclosure of such materials 30 days prior to the opening of the prosecution's case would be inadequate. I invite the SPO to give any further submissions on the estimated amount and type of material it intends to disclose, the redactions that will be required, and any other details the SPO wishes to provide in relation to this category of evidence. Madam Prosecutor.
Thank you, Your Honor. Yes, as submitted in writing yesterday, the SPO plans to complete its Rule 1021B disclosure obligation by the 30th of July 2021 in any event 30 days before the beginning of the prosecution case and pending any translation. As I have anticipated at the beginning of the hearing, the number of witnesses shouldn't exceed 8, and we expect that the additional documents won't exceed a total of 50 for a complete amount of 100, including also the indictment supporting materials. With regards to translations, as we are continuing our review of documents to identify the documents that will be falling within this category, of course, that will also follow. And we expect that the materials falling within witness statements will be translated by the deadlines. And with regards to Your Honor's last point regarding whether we foresee reductions and protective measures, we do believe that it is possible that some of the remaining witness-related material and some of the documents may follow within the category that requires protective measures or other type of reductions, or may follow under Rule 107 and may require special orders. Thank you, Your Honor.
Thank you, Madam Prosecutor. Duly noted. I turn to the defense. Mr. Rayuni.
Thank you again, Your Honor. Just a quick clarification point on this matter. We have noted yesterday a slight discrepancy between paragraph 2 and paragraph 9 of the submission of the prosecutor in relation to the date mentioned as 30 July. In one paragraph, it seemed to mean that this would be the date where it would be in a position to start making these disclosures, and on the other, it seems to be the date where it's in position to complete that disclosure. My learned friends were very helpful today. We had a quick chat. We could clarify this, and Monsieur Dice clarified it, so we appreciate that. That's all we had to say on this.
Thank you, Mr. Ayoni. I understand it that it is when you will be done with the disclosure of this material, correct? To avoid any misunderstanding, but that's how I understood your submissions.
Yes, Your Honor. The materials would be provided on a rolling basis until the final date of 30th of July. Thank you.
Thank you, Madam Prosecutor. Now let us move to the next item in our agenda today, related to the evidence material to the defense preparation, known as the Rule 102.3 material. I would like to remind the SPO that disclosure or inspection of evidence such as statements, documents, photographs, or tangible objects material to the defense must be disclosed without delay. The detailed notice of such material must include not only information the SPO assesses to be potentially material to the defense preparation, but any material and evidence in the SPO's possession which has not been disclosed under Rule 102.1a and b and 103, and which is relevant to the case. I also remind the parties that disputes as to the materiality of the information, as claimed by the defense, must be submitted immediately to the pretrial judge for resolution. I also take note that the SPO anticipates providing the defense with a detailed notice of the Rule 102.3 material by September 3rd, 2021. And I also note that the defense for Mr. Shala requests that evidence material to the preparation of its case be disclosed immediately or as soon as possible, or in any event by 22 May 2021. I invite the SPO to notably indicate for this category an estimation of the type and amount of material, the redactions that will be required, and any other details the SPO wishes to provide. Madam Prosecutor.
Thank you, Your Honor. At this stage, as indicated in writing in our submissions yesterday, we foresee this list to comprise not more than 3,000 documents. Of course, the review is ongoing, and we foresee this to be the maximum number, but there could be differences. We also foresee that part of this material may require reductions or protective measures requests, and as Your Honor stated, we do propose to provide detailed notice to the defense by the 3rd of September 2021 upon completion of the Rule 102.1b disclosure obligations. This proposal is in line with the practice of this court to have a disclosure process organized in a way that allows to submit as last any residual information after the items to be presented at trial and the items potentially or exculpatory have been disclosed. It is in our submission the most efficient way to proceed, and the way that will avoid both delays and duplication of work. For this reason, we submit that the date of 3rd of September is the most practical date. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. Mr. Ayuni.
Thank you, Your Honor. I think it's fair to say that it's probably a bit too early to set dates or to make a definitive, or at least a position or an indication that is useful to your honors. I think as we get to ourselves acquainted with the most relevant materials, we will be able to see the impact and the content of the documents, and be able to come to the prosecutor through our discussions as to realistic estimates. Obviously, in the abstract is very easy to say this date or the other. We don't oppose, in principle, it makes sense that it might come at a later stage after the first two categories of disclosure. It makes perfect sense. It will allow us to deal and assess, especially with Mr. Shala, the essential documents. And I'm sure if we identify documents that are material to us, we might always take contact with the prosecutor for a punctual disclosure of certain material we get aware of. Thank you, Your Honor.
Thank you, Mr. Ayuni. I think the parties are in agreement that this sequencing of disclosure aims mainly at avoiding duplication, which I think is an important point for efficiency. Just one follow-up question to the prosecution. would you be able to disclose this notice a little earlier, or would the 3rd of September be the earliest possible for you?
Your Honor, the 3rd of September would be the earliest date for us, also taking in consideration the summer recess and a few days that are necessary to have a careful assessment of the materials so that it can be effectively meaningful for the defense. Thank you.
Thank you, Madam Prosecutor. Let us now move to the next item in our agenda, which is the exculpatory evidence known as the Rule 103 material. I remind the specialist prosecutor that this evidence must be disclosed immediately to the defense as soon as it is in its custody, control, or actual knowledge, which is when it reasonably suggests that the accused innocence or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence. Disclosure of exculpatory evidence is a continuous obligation, subject only to protective measures where necessary. I note that yesterday the SPO already disclosed a first batch of potentially exculpatory material. So I invite the SPO to indicate the amount and type of exculpatory material, whether redactions will be required, and any other detail you wish to provide. Madam Prosecutor.
Thank you, Your Honor. Indeed, as indicated, the SPO has already started its Rule 103 disclosure obligations and will continue to fulfill this obligation in accordance with the rules and disclose all Rule 103 materials within its custody, control, or actual knowledge. With regards to yesterday's disclosure, I would like to make a correction to what was submitted in writing. The total number of items was in fact 15 and not 14. This is because we added the Albanian version of one item, and that changed also the total number of pages disclosed to 1,045. There was one witness statement, and the number of statements obtained from the accused was 5 and not 54, as incorrectly noted in our written submissions. The number of transcripts parts were a total of 2, and the number of other documents 6. With regards to the remaining Rule 103 disclosure obligation, the SPO will continue to review and following any application for reductions wherever necessary, immediately disclose any such items falling within this category. We do expect that some of the Rule 103 materials might require reductions, in particular pursuant to Rule 108.1. Thank you, Your Honor.
Thank you, Madam Prosecutor. Mr. Awini.
Thank you, Your Honor. We have nothing really to note regarding that. The obligation of the special prosecutor is ongoing, continuous. Disclosure of these material are statutorily mandatory and immediate, so we will just leave it at that. Thank you.
Thank you, Counsel. Let me now move to the next category of material, which is the protected material known as the Rule 107 material. I take note that the SPO foresees that the limited amount of material falling under Rule 102 and or 103 is protected under Rule 107. I would like the SPO to notably indicate the amount and type of material that still requires clearance, whether the SPO has already taken steps to obtain the consent of the information providers to disclose such material, or whether such steps are foreseen in the near future, and whether the SPO intends to apply to the pretrial judge to be relieved in whole or in part of its obligation under Rule 102 and or 103 of the rules to disclose the initial material, and whether redactions will be required. Madam Prosecutor.
Thank you, Your Honor. Indeed, a limited amount of material might fall within this category. It is not possible at this time to estimate exactly the amount of material that might require Rule 107, that might fall within the Rule 107 protected material. However, Your Honor, we have taken steps for any material that has been identified so far. We have taken steps to ensure to start the clearance process. Of course, at this stage, it is difficult to foresee whether we will have to apply to be relieved of our obligation under Rules 102 and 103 until we have received responses from the providers. However, we will promptly inform the pretrial judge should this happen. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. Do you have any specific comment on this category of material, Mr. Awini?
None at this stage, Your Honor.
Thank you, Mr. Awini. Now we will move to the next item on our agenda, which is the procedure for disclosure, and notably the use of case-specific categorization in legal workflow for material falling under Rule 102.1a, b, and Rule 104.1, 5, and 6 at the time of disclosure of each batch of such material. In its submission, the SPO indicates that subcategories additional to the statutory categories foreseen by Rule 109C would be of very limited assistance, if any, and would be a time-consuming process. The SPO also submits that a consolidated disclosure chart should be provided within 15 days from the filing of any pretrial brief. The defense accepts the proposed adoption of the case-specific subcategorization in legal workflow, and as mentioned by Mr. Gilisen earlier in this hearing, the defense also proposes 2 additional subcategories. The defense also requests to be provided with the consolidated disclosure chart as soon as possible, and in any event, well in advance of the filing of the prosecution's pretrial brief so that it can properly prepare for trial. I invite the parties to give further detail on this topic and, of course, especially on the subcategories in legal workflow that have been recently implemented in another case. Madam Prosecutor.
Thank you, Your Honor. Yes, as submitted, it is the SPO's position that any subcategory additional to the statutory categories foreseen by Article 109, by Rule 109C, will be of limited or no assistance to the defense. For example, should the subcategory Pjetër Shala be introduced in this case, we cannot see any document that will contain the tag for Pjetër Shala but not for accused. And similarly for location cookies, that being the only location, it will automatically be tagged together. The same applies to some of the additional subcategories proposed because of the nature of the evidence in this case, it will become clear that each item might cover almost all of the issues. It will be only a very limited amount of items that might cover just one issue or one underlying crime, for example. We do understand that in a case with a larger amount of evidence, this kind of categorization may be effective. However, in this case, we believe that it will be of no benefit to the accused. Thank you, Your Honor.
Just a follow-up question, Madam Prosecutor. I take your point for the location, but for the counts and for the modes of liability, there are several counts that refer to several crimes, and there are also several modes of liability in the indictment. So what about the subcategorization related to these topics?
Yes, Your Honor. As briefly mentioned, we believe that each item might cover an extensive amount, for example, of underlying crimes. Therefore, it might end up being tagged for all of the underlying crimes and all the modes of liability, rendering effectively the exercise of no assistance to the defense. It's really by looking at the specificity of the case that we can say, in our view, this will be of limited assistance because of the nature of the evidence, because of the limited time frame of the indictment and the evidence to be presented. Thank you.
Thank you, Madam Prosecutor. Before giving the floor to the defense, just a couple of information on the context. This issue of categorization has been debated in other cases, in previous status conferences. We've had the questions of disclosure, charts, notably when they had to be prepared by the SPO, what categories they should include. And in another case, I ordered actually the categorization to be made directly in legal workflow through a recent upgrade of the system, which is done through categorization that allows not only to basically get the material in an organized way through different Excel spreadsheets that can be generated within the system, but also for any parties to search for evidence combining different categorization so as to be able to search for evidence as faster and expeditiously as possible. So after this little reminder, I give the floor to the defense.
Thank you again, Your Honor, and we fully take your point on the follow-up question regarding the modes of liabilities and accounts. It is mentioned in our submissions. We would like to have those categorizations. We had a small discussion this morning with our colleagues from the SPO. We might discuss that further, but at this stage, we don't expect to litigate this, but at this stage, we cannot assume or presume the absence of additional charges, the absence of joinder to other cases, or any things of any procedural events that might happen that would render these categorizations absolutely essential. So we take no firm position at this stage other than the ones we made on our written submissions, and maybe we will be able to assist you further at later conferences.
Thank you, Mr. Iwini. Madam Prosecutor, do you want to add anything on this topic of the procedure?
Yes, Your Honor, just one additional point. I hope it is clear that what we are opposing is just subcategories, because of course with the, any search and any filter will still be possible for the 4 categories foreseen by Rule 109C. So that would remain a tool that the defense would have at its disposal. Thank you.
Thank you, Madam Prosecutor. Now let us move to the last item on the agenda, which is the redaction regime. In adopting a redaction regime, it is necessary to ensure the efficiency of the disclosure process while striking a balance between the duty to protect the interests of the victim and witnesses and upholding the rights of the accused. In their submissions, the SPO and the defense both agree to adopt the redaction regime applied in the Gucati and Haradinaj case. I invite the SPO and the defense to make further submissions on this topic. Madam Prosecutor.
Your Honor, we agree with with Your Honor's proposal to apply that reduction regime. Thank you.
Thank you, Madam Prosecutor. Mr. Awini.
Yes, Your Honor. Our position in principle that the proposal seems absolutely reasonable and agreeable. Should we later, at a later stage, discover something worth noting to Your Honor, then we will not fail to do it. But as it stands, the proposal seems agreeable to the defense.
Thank you, Mr. Awini. At this point, I would like to ask the parties whether they have any other issues they would like to raise. Madam Prosecutor.
Thank you, Your Honor. Just one final point regarding the provision of the Rule 109 chart. In the prosecution submission, this chart requires a fully finalized pretrial brief in order to be produced because it draws from that analysis. And I just wish to note that while this would be coming after the pretrial brief, the accused would have at its disposal the detailed outline, which contains count by count the evidence relevant for each count, and of course every single item disclosed will be similarly categorized. Therefore, there will be no prejudice to the accused by receiving the chart after the pretrial brief. Thank you.
And do you need 2 full weeks, or would 1 week be enough for this?
Your Honors, we do need the 2 full weeks. Thank you.
You're very demanding today. I turn to the defense. Would you like to add anything, or is there any other issue you would like to raise in this hearing?
Just on this specific point, maybe Mr. Gilisen has some comments to make later on, but just on the issue of the chart, again, we agreed with the SPO to discuss that further. As we know more about the case, the way it's been arranged and the way things are going, then probably we will come with a reasonable suggestion. But in any case, what the defense says is that the deadlines or the timelines that are applied to the SPO should be the same as the defense, at least in terms of margins. Thank you, Your Honor.
This is noted. Mr. Gilisen, do you have any other points you would like to raise in this hearing?
No, thank you very much. Nothing else. Thank you.
Thank you. I would like to ask the parties now on their views about the next status conference, especially what date. I note in this regard that should the counsel or the accused wish to participate via video conference, written notice shall be sent via email to the registry 24 hours in advance of the relevant hearing so that arrangements can be made. And such notice should include the written consent of the accused, as the defense actually did for this status conference. Madam Prosecutor, on the date of the next status conference.
Thank you. We will be ready at Your Honor convenience. Your Honor, thank you.
Thank you, Madam Prosecutor. Now I turn to the defense.
Thank you, Mr. President. Concerning the setting of a new date for the next statute conference, we would benefit from a period of few weeks where we can finalize the setup of the defense team, as I told you at the beginning of the hearing, and to deal with some urgent matters, including the question of detention of Mr. Shala. Thank you very much.
Thank you, Mr. Gilisen. Do I take from your submissions that end of May or early June would be appropriate for you? Or do you need more time?
I think early June could be nice. in my opinion, the best is the end of June. But if it is necessary, we will prepare to be able to appear in the beginning of June. Thank you.
Thank you, Mr. Gillissen. This is noted. You will receive a scheduling order that will include the agenda before the status conference. And I also invite the parties to make written submissions if they would like to raise any specific issue during the next status conference. This concludes today's hearing. I thank the parties and the registry for their attendance. I also, as usual, thank the interpreters, stenographers, security personnel, and audiovisual technicians for their assistance. The hearing is adjourned. Thank you.
All rise.